My name is Amanda Sauls, and I am counsel at the Beckett Fund for Religious Liberty and a member of the Federalist Society's Religious Liberties Executive Committee. And I have the privilege today of introducing the moderator for our next panel, Judge Reed O'Connor, who will guide us in a discussion on the future of free speech in an increasingly digital age. Judge O'Connor is a federal judge on the United States District Court for the Northern District of Texas, where he presides over cases in both the Fort Worth and Wichita Falls divisions. Prior to his confirmation in 2007, Judge O'Connor started his career in private practice and then served in both the legislative and executive branches, including as chief counsel to Senator John Cornyn and as an assistant U.S. attorney in the district in which he now serves as a judge. Since taking the bench, Judge O'Connor has adjudicated many of the high-profile cases in the Texas district courts, including several significant statutory and constitutional challenges to government action. And time and again, he has demonstrated his fearless commitment to applying the law as it is, not as he or others think it should be. So Judge, thank you, and thank our panelists for being with us this afternoon, and I will leave it to you to introduce our panelists.
Thank you, Amanda, and I want to thank the Federalist Society for inviting me. And I will just say about Amanda, I put her on an appeal a couple of years ago as pro bono counsel. She clerked on the circuit as well and volunteered to help a criminal defendant and argue on his behalf in a very difficult case that not many people would take, and her fearless commitment to the rule of law and to help people who are charged when she's called upon to serve the law in that capacity is to be commended. So thank you, Amanda. But anyway, I wanted to thank the Federalist Society for inviting me to moderate this panel. It really is my privilege to be sitting up here with these subject matter experts. I've seen part or all of the panels, including the lunch portion today, and you just have to give it to the Federalist Society's staffers who put this together. As usual, they have assembled an excellent day of discussion. So thank you all very much for that. In the last term's net choice case, all members of the Supreme Court agreed that the plaintiffs in that challenge to the social media regulations that Texas and Florida imposed on social media platforms failed to state a facially unconstitutional challenge, or failed to prove it in the injunction stage. 4 of those justices opined on how traditional First Amendment principles would apply to as-applied challenges to those regulations as it relates to portions of the plaintiff's members' social media platforms. There were 3 other opinions where the remaining 5 justices wrote that they could not sign on to the as-applied portion of the majority opinion. They felt it was dicta and that it was premature to sign onto that. These justices believed that more information was needed about how the platform's algorithms implement content moderation, or as the Florida statute calls it, how the platforms censor users' content, before they could weigh in on how the First Amendment applies in that context. Finally, Justice Alito wrote, and he was joined by Justice Thomas and Justice Gorsuch. He wrote that when evaluating the challenges to these regulations, the lower courts should seriously consider the state's arguments that the platforms are common carriers. Now, how significant would this finding be, and what would it mean to this particular industry? Well, let me introduce to you those who have an idea on what that would mean. The first person I would like to introduce to my immediate left is Benjamin Flowers. Mr. Flowers is a name partner at Ashbrook, Byrne, Kresge, and Flowers. I'm sorry, I knew I was going to mess that up, but he's a name partner at that firm. He is an accomplished litigator and previously served as Ohio's 10th Solicitor General. Most prominently, he led the multi-state challenge to the OSHA vaccine mandate in National Federation of Independent Business versus the Department of Labor. He is a former law clerk on the Ninth Circuit and a former law clerk on the U.S. Supreme Court for the late Justice Scalia. And for Mr. Flowers and for all of our panelists, I would refer you to their online biographies. I just want to hit the high points now so you have some feel as we get into this. Next to Mr. Flowers is Professor Ganesh Sitaraman. He is the New York Alumni Chancellor's Chair in Law at Vanderbilt University Law School, where he has been since 2011. The professor's most recent book is, quote, The Great Democracy, How to Fix Our Politics, Unrig the Economy, and Unite America, close quote. He is also the author or co-author on a number of substantive publications. He has been a public policy advisor and was a law clerk here on the D.C. Circuit Court for Judge Stephen Williams. There's no way I would fail to point out that he is also an Eagle Scout, which should always rank at the top of anyone's biography if they were able to accomplish that in the time period that they are allowed to do that. To his left is Jennifer Huddleston. She is a senior fellow of technology policy with the Cato Institute. Her research focuses on the interaction of emerging technology and the law, with a particular interest in the interactions between technology and the administrative state. She has also written with expertise on judicial deference, liability protection for internet platforms, and a number of other subjects. And during the previous panel, I had my eye on her because I know she had lots of comments to make on that panel, and she's going to share some of those with us here today. And then to her left is Mr. Thomas Johnson, Jr. Mr. Johnson is a partner at Wiley, Rein, LLP. Prior to joining Wiley, he was the general counsel at the Federal Communications Commission, where he served as the agency's chief legal officer and was knee-deep in the not-forgotten net neutrality policy consideration by the agency. I could give more of his biography, but I think I would just end it by saying anyone who is knee-deep in that debate and didn't cause the internet to just collapse and break needs no more said about them. So thank you, thank all of you for being here. So let's get started, and let's start with Mr. Flowers. Mr. Flowers has a unique perspective on the net choice litigation. He played maybe a tangential role in the litigation, and so Mr. Flowers, why don't you kick us off and tell us what the state's concern was and how should a state regulate social media platforms if they can?
Sure.
And with the goal to protect and promote First Amendment.
Yeah, thank you for having me. It's an honor to be here. Look, it is a Federalist Society event. I got a little worried it was an ACS event when I heard the previous panel talking about soccer, but it is a Federalist Society. Yeah, I think I would have gotten a standing ovation in Texas or Ohio or Tennessee for that one. But yeah, no, it's a Federalist Society event, so there's no better place to start than with Justice Scalia. And I want to go back to first principles and then bring it home to what we're talking about here. You know, Justice Scalia had this great canned speech he would give at law schools around the country, and he'd often ask the students, what's the most important part of the Constitution? What is the part of the Constitution that makes America so exceptional? And almost without fail, the students would talk about the Bill of Rights, but in particular, they would talk about the free speech clause. And does anyone in here agree with that? Yeah, raise your hands. Well, he would say, wrong. He would say, look at the Soviet Union, look at North Korea. They have wonderful protections of speech. Far broader protections, in fact, than the United States has, but none of it matters. And the reason it doesn't matter is because they don't have separated powers. And he said, what makes our Constitution so special is the separation of powers, because that is the real check on abuse of power by each of the individual branches. The other branches can reach out. The states can do things, as you heard from General Scrimeti, to counteract federal overreach. And so our whole Constitution is based on this brilliant recognition by our founders that a concentration of power is dangerous. And the reason that it's dangerous is that we're fallen creatures. Human beings tend to abuse whatever power they have. And so rather than wishing that away, rather than pretending people would behave as angels, we harnessed that tendency to abuse power and said, well, as long as each branch has the ability to use its power to check the abuses by the other, that'll help us keep everyone in check. And so you might say, what does it have to do with what we're talking about now? Well, I think that insight that people tend to abuse power and that we need checks on power is relevant in the social media context. Now, look, I went to University of Chicago. I'm a Chicago guy, and Chicago School of Economics, if you will. And so I'm a capitalist. And one of the many virtues of capitalism is that it provides an inherent check on the abuse of power and the concentration of power. If a company is abusing its power, if it's taking advantage of customers, it's not going to be in business very long. Someone else will rise up and put it out of business. At least generally, there are exceptions to that, and our law accounts for those. One of those you heard about in the last panel is antitrust law. And antitrust law exists because it recognizes that sometimes when competition breaks down, the law has to be there to reinvigorate competition so that that check can come back into play. And I think that brings me to the social media networks. And so I was SG from 2019 to 2023. And during that period, I think there started to be a lot of thought about these social media companies and whether, because of the sort of network effects of social media, meaning the fact that your social media network just isn't worth anything unless it's really big, maybe these entities had so much power that they had the ability to abuse it and not get the typical market check you might see otherwise. And so maybe the law had something to say about that. Maybe states, maybe the federal government needed to get involved to make sure that there was more competition. And that became a particular concern, I would say, in 2020, and for really two reasons. Number one, the election. There was the mass suppression on social media networks and in the news, frankly, of the Hunter Biden laptop. People weren't allowed to talk about this, may very well have swung the election. And so there was concern that these are incredibly powerful entities that are effectively operating, to use a cliche, as the modern public square. This is where people are debating politics, where they're sharing news, and if there's there are important ideas that are being censored that people aren't able to discuss, it will affect our political system, affect our system of government eventually. And I think the other main area of concern with respect to censorship was COVID. And so you saw suppression of people who questioned where the virus came from, whether it was made in a lab versus the sort of establishment story that it was that it arose organically. You saw suppression of doubts about masks and vaccines. And again, I think a lot of state actors became concerned that this is a very important matter. It's having a direct bearing on all of us, and particularly children going to school. And so the suppression of speech on this is incredibly disturbing. But of course, while it may not be the best part of our Constitution, the separation of powers is, one very amazing part of our Constitution is the free speech clause. And so obviously the first thing that the social media companies might look to say, you can't stop us from censoring, is the First Amendment. That might sound odd. How is censorship protected by the First Amendment? But in a lot of contexts it is. If you think about a newspaper, for example, they have the right to share a message, and so to compel them to carry a message they disagree with would be compelling speech. And so in combating censorship, you're actually infringing the newspaper's free speech rights. And so I think states began to think hard about this, and a few questions emerged. One is, are these social media companies engaged in speech when they censor these views? Are they trying to communicate a message? Or in general, are these forums for speech, which generally in some contexts get less First Amendment protection, or are they speaking themselves? So there's a case called Prune Yard from, I think, 1980, but definitely the 1980s, in which the court upheld against the First Amendment challenge a California law that required a mall to allow leafleting on its property. And it said no, the law, you're not speaking, it's not making you speak, it's just barring you from precluding people from speaking as they would like. And so I think many states thought that social media companies look a lot like that. They're not trying to curate a particular message in many cases. They are instead a forum that's open for people to speak their mind as they see fit. So maybe the First Amendment doesn't apply for that reason. But then also, a lot of states began looking at a doctrine I think a lot of us had never heard of before this, the common carrier doctrine, which I won't elaborate on because others who know more about it will. But the idea of a common carrier is, like a train or a telegraph back in the day. If it's a technology that is generally open to the public, the company, as a condition of being able to provide that service, has to take all comers. And so maybe social media is like that. Maybe social media companies are open to the public. They do generally take all comers, and so they can't discriminate on the basis of a message. And you can see the appeal of that argument without getting too much into the doctrine. If you think back to, say, an actual example would be the telegraph or the telephone. If telephone companies were to say, we offer this incredibly important service, but if you want to use our services, you cannot use them to promote the election of a Republican or a Democrat or some other view with which we disagree. And so in light of those, states grasped onto those views that maybe the First Amendment doesn't apply at all because the social media companies aren't speaking, or maybe it doesn't apply because of this common carrier exception. And a couple states, relevant here, Florida and Texas, passed laws aimed at addressing censorship. So they're long, complex laws, but speaking generally, limited the ability to censor speech because of the content of the speech or the viewpoint it's trying to espouse, required the social media companies to at least publicize the rules basically that they used in deciding what to censor from their networks, and allowing a sort of an internal appeal if you are banned from the network to say that the company's rules were not applied correctly or in an even-handed manner. And so those laws, not surprisingly, it's America after all, led to a lawsuit, and that lawsuit eventually made its way to the Supreme Court, which resulted in the opinions that Judge O'Connor just mentioned. I think with that, I've discharged my abilities, or my responsibilities as a introductory speaker, so yes. That's the problem, and I'll let others jump in at this point.
Very good, and thank you. And I want to get to the professor next, because he is a subject matter expert on some of these issues. Before we do that, anybody else have any other background facts, or we can rely on Mr. Flowers' presentation, which was very good. Anyone else? Good. So, Professor, just as I mentioned, Justice Alito wrote a concurring opinion and addressed a host of issues there, as well as this common carrier idea that, and he essentially said that the lower courts need to give serious consideration to the state's argument that this should be evaluated under the common carrier doctrine. As you know, Justice Thomas, I think of the term before, so we're going back 3 terms now, wrote a statement on the denial of cert in the Trump Twitter case where he blocked people from being able to comment on his Twitter feed. That case was denied cert as moot because President Biden was elected, and so it mooted it. But tell us the significance of that. If the lower courts determine that the common carrier doctrine would apply, how would they do that? What would lead them to say something like that, and then what would be the consequences of that?
Well, thanks, Judge, and thanks everyone for having me here. I'm excited to talk about this topic with everyone. What I thought I'd do is answer the question, but by way of giving a little background, because I think there's probably both in the room and people watching at home a large range of knowledge on what exactly is the common law of common carriers, how does it work, and how should we think about it. And so for that, I'll take you back to 1881 and to a case from Louisville, Kentucky. And in Louisville, Kentucky in 1881, there was a carriage and omnibus company, and you could think of this as like a taxi service. And they wanted to get a telephone. The telephone had just been invented 5 years earlier, 1876, by Alexander Graham Bell. Brand new technology, unbelievably transformative. Just imagine you can hear somebody else's voice from a distance, a shocking development in the history of technology. And this carriage company, basically a taxi service, wants to have a telephone line so people can call them and book the services. They are denied by the telephone company because the telephone company also owns its own carriage company, and it doesn't want to give a telephone line to a competitor. So the court gets this case when the carriage company sues, saying we should have access to this. And the judge looks at it and says, you know, this is a brand new technology, but it is a common carrier technology, and I'm going to designate it as such under the common law, even though it's a new technology, and as a result, the telephone line cannot be denied to this carriage service. That's the case, 1881, and I think it really illustrates some interesting principles that are relevant to the discussion that we're having here today about the importance of access to specific kinds of businesses. Not every business, but some businesses that are in the form of essential services where there are often network effects, high capital costs. It's difficult to replace those services or come up with an alternative to them. They might be natural monopolies or natural oligopolies in their nature. And this kind of business, one that was unlikely to be in a totally competitive industry, was one that was recognized really from the late Middle Ages to be one that needed to be governed differently than ordinary businesses. And judges in the common law tradition designated such businesses on a case-by-case basis as new technologies and businesses emerged as common carriers. You may have heard of this sometimes as the law of innkeepers in common carriers. It included a wide range of things from horseshoeing blacksmiths to wharfs on the water to innkeepers to the markets in small towns. So a wide range of activities. And if designated a common carrier in such a case, there were a number of principles that then might apply. I'll focus on three of them here that I think are most relevant to our conversation. The first is a kind of equal access rule, and this is the point that Ben just referenced, that if you're a common carrier, you have to accept all comers. You can't deny or turn people away for irrelevant characteristics or just based on who they are. This is the idea here of the telephone company being able to give a telephone line even to their competitor carriage company. You can't just deny someone access. You have to accept all comers. The second thing is a requirement that you charge a just and reasonable price. There was price regulation built into the common law in this system. You couldn't charge too high of a price, and you couldn't give special deals. And these all evolved over time as cases fleshed out the specific mechanisms. But this is an important part because you can deny equal access, the duty to accept all comers, by charging an infinite price. If the price is $1 trillion, no one can have access. And if we differentiate prices and say, well, the price for you is $1 trillion, but the price for the person next to you is 2 cents, you've functionally not accepted all comers, even though you say you're accepting everyone. So a requirement of just and reasonable prices. And then third, there was an exception to the duty to accept all comers that I, in work that I've done, call reasonable deplatforming. And the idea here is effectively that you are, as a common carrier, allowed to exclude some people under very limited circumstances. And so I'll give you a couple of examples. Innkeepers were allowed to exclude thieves. You don't want to include in your inn someone who's going to steal all the stuff from your other patrons. If your goal was to ride the railroad in order to destroy it, the railroad can exclude you. You're going to end the service altogether. So there were limits on what we could do. They were not based on political views, religious views, other kinds of personal characteristics, but there were some outer bounds to the obligation to keep all comers. Now, I think this understanding of the common law of carriers is important in part because there's a very good argument that you've already been kind of twisting around in your head and thinking about that this could apply to tech platforms. They are important services in a modern economy. They tend to have network effects, as Ben mentioned. It's very difficult to replicate these facilities or find alternatives to them. They either are monopolies or oligopolies in the various sectors in which they operate. There's a large element of dynamic innovation that's involved by having access to these things. You can create other kinds of beneficial innovations. And so if you're excluded, it's a serious problem. And so there's a good argument that this applies. And the common law still exists. The common law of common carriers was never, the Congress never came in and preempted the common law of carriers in every state. That has not happened. And so I think the puzzle here is, why aren't there more cases about this? And I think we have, in part, forgotten about this concept, even though, first-year law students learn torts and property and contracts, all these kind of common law principles. Common carriage is not a kind of major component of the curriculum for most lawyers. And I think what that has to do with these cases today is really 5 things. I think there are some important payoffs for thinking about this history. The first is that the major benefits of this doctrine tended to be in business-to-business cases. And so a little bit less useful if you think about businesses to consumers. There's some value to that. We'll talk about that in a moment. But the application in situations like Amazon Marketplace or Google in the search context, and in Ohio, for example, there was a suit against Google arguing that Google is a common carrier. So business-to-business cases, I think, a lot of value here. The second is that it may in some ways be a little bit less useful to those who are primarily interested in requiring tech platforms to accept everyone and all types of speech under all circumstances as an absolute matter. And the reason is there was this limit for reasonable deplatforming that courts recognized in a whole bunch of different ways. And we can think about where the boundaries of that are and what should be included and what shouldn't, and where the First Amendment gets in. I think in the context of social media platforms, unlike commercial marketplaces, for example, would mean that that scope is going to be smaller for what could be excluded. But there still may be some space. We do, of course, have limits on the First Amendment and certain kinds of speech that can be regulated. The third point is that common law judges were not afraid to use the common law. They recognized that new technologies needed to be regulated also, and part of the point of the common law was to be a backstop to regulate when new things emerged. And you reason from situations that we already know about to reason to new situations. That is what the common law is about. And so common carriage in some ways works very nicely as a backstop regulatory set of principles, even when we have new technologies. The fourth point, which I think the Louisville transfer case really shows quite well, is that it really matters to get into the details of what business lines we're talking about. We often talk about social media. That's a very broad term. What actually matters, I think, is to look at the specific business lines. Are we talking about a one-to-one messaging service? Are we talking about many-to-many communications? These are different things. And the way we analyze the problem, whether common carriage rules apply, the limits, the scope, should differ based on the specific business line. And so that's an important part of the story as well. And then the final point is a story about federalism. And any discussion of the common law is a state-based story because the common law is a state-based set of principles in our current system. And I think one of the virtues of that is that it allows for new kinds of arguments and experimentation at the state level. It's one of the benefits of a federal system that we have. But it has a second benefit too, which is that when industry groups don't like it at the state level, but states impose these kinds of rules, whether it's through judge-made common law or through legislative action, it creates pressure at the federal level to actually come to an agreement on a set of rules that will apply across the whole country. And I think there's a virtue to that as well. So with that, I think I'll stop, but it's just to say I think there's a lot to say for the common carrier idea and how it can apply to these cases and how we think about tech platforms generally. Thanks.
And thank you for that. And just two quick points. One is your point being essentially the details matter. Social media is a broad term, but the details matter is a very good point, and I think that's across all of the opinions in the net choice case. The second point, at least at a very high level, in the Justice Thomas opinion in the Columbia University Biden, the Trump Twitter commentary block case, Justice Thomas talks about common carrier and public accommodation. At a very high level, those roughly parallel what you've just talked about?
Yeah, in some ways they do. They have overlapping and different traditions that they draw on. So
Okay.
I think there's some overlap there. Yeah.
Okay, good, thank you. And Ms. Huddleston, thank you for being here. Thank you for your patience, because we're very excited to turn the floor over to you. But let me let you address whatever you want to address, but let me also throw out there that it appears that Texas and Florida's legislation was motivated, at least in some fashion, about the lack of market access by people in this space. And so what is your view on the consequences of characterizing digital platforms, social media platforms, as common carriers or public accommodations? And how would you see that playing out if that were to take place? Anyway, the floor is yours.
Well, as you may be able to tell from Judge O'Connor's question, I do not believe that these platforms are common carriers, and it would probably be a pretty boring panel just to hear go back and forth, yes, no, yes, no, yes, no. In part because I think that when you look at how these platforms behave, they don't act as common carriers. They've long had rules of access. And when I say these platforms, it's important to recognize that when we're talking about social media platforms or when we're talking about online platforms, we're talking about far more than Facebook, Twitter, and YouTube. We are talking about a wide array of platforms, including things like Truth Social, including things like Discord, including a variety of apps that would have found themselves potentially subject to these kind of must-carry requirements. And in fact, it's largely been the fact that the U.S. has taken a deregulatory approach in the online space that has kept those barriers to entry low, that allows us to have a wide array of options in the market when it comes to online platforms, and new options coming online all the time. In fact, if you think about the difference in the number of platforms we had in 2020 and the platforms that we have today, you might be thinking about different platforms. I'm a millennial, and if there's anything that makes you feel old as a millennial, it's what social media platforms you are on versus what social media platforms the law students I teach are on, because I will tell you, what you find is that oftentimes competition and innovation have been our best policy when it comes to changing the dynamics of this market. Of course, we have some platforms that are used for more general purposes, but we also have platforms that are used for very specific communities that are incredibly important to those communities and have their own rules when it comes to content moderation. Before I move on to my second point, which is also going to be tied to this weird little nitpick that I have, but it's really important to me in this conversation, is around the use of the term censorship. And I say that because one of the concerns I have is, what would it actually mean if we saw these platforms become common carriers? And not only to me would this mean that you have less competition in the market, but you're going to have barriers to entry, it also means something a lot around the term censorship. Oftentimes in the technology space, we hear the term censorship thrown around to mean, I don't like the rules the platform enforced or how they chose to enforce them. To be clear, that's fine. You don't have to like the rules a platform has or how they chose to enforce them. However, there's a quite significant difference in a platform's decisions around its content moderation, around what speech it chooses to associate itself with, and an enforcement by the government or by a government around what speech must be carried or must not be allowed. And this is incredibly important when we're talking about a potential categorization as common carriers. Because to categorize online platforms as common carriers is going to allow the government far more intervention into what kind of content they are carrying and into the rules that they are operating under. This shifts away from the larger deregulatory approach that has really allowed the internet to flourish in the US and has really created those low barriers to entry. It would mean not that a platform is necessarily fully making these decisions, but if we saw something like Texas or Florida's laws, that you have the government making the decisions around what content must be left up or must be taken down. And when we're talking about this in the context that it often gets brought up of political content, it's important to remember that we're talking about more than just the two major political parties. When we're talking about things around political candidates or around political content, it's much broader than just the two political parties. It can refer to anything from neo-Nazi content to other content that might be considered to be political in its very nature, and that can be at play here. Additionally, when we talk about common carrier requirements, you could see that it would be harder for those smaller platforms to get started as a result, and that would mean that you actually have more concentration in the market when it comes to those who are concerned about the actions of these large platforms. Even if there's some sort of exception where a platform isn't considered subject to these requirements until a certain number of users or until a certain number of months in business or any other kind of metric, what you're then potentially seeing is that the government could distort the market by making that next user be your most expensive user, because you're going to be subject to all sorts of new regulations. Even if there's some sort of escape hatch, some sort of affirmative defense around a decision that was made to the kind of point of you don't have to allow a thief in your hotel, for a small platform, the cost of that litigation could be potentially business ending, meaning that, again, you would have fewer players able to be in the market. And then finally, I would like to point out that there are some things around common carriers and the First Amendment that we know at law that I would like to point out that mean that a common carrier does not lose all their First Amendment rights. If you look at the PG&E case, particularly around these must-carry requirements, I think it's important to note that even if these platforms are considered to be common carriers, they still have First Amendment rights, particularly in certain contexts, and that it would be important to recognize that they would still be able to engage, and important that they engage in content moderation, but that we would have a lot of concerns about how this could impact both potential competition, how this could impact players of all sizes, as well as how it could actually make it more difficult around certain kinds of speech. When we're talking about this additional government involvement, it's important to think not only how would you feel about this power when people you agree with are in charge, but also how would you feel about this power when people you disagree with are in charge. Because if we know anything, it's once power is given to a government, once we're talking about government censorship, not just I don't like how this platform chooses to engage in content moderation, it's a lot harder to undo that. And there's not necessarily that ease of being able to switch or being able to share on multiple platforms that we experience in a free market today.
Well, thank you. Let me follow up briefly before we move on to give anyone else a chance to comment on what the professor has said and what you have said. First off, I think it's important to note that Justice Thomas, Justice Alito have not weighed in to say that these are common carriers or public accommodations. They've simply noted that the states have made that argument and it deserves serious consideration. But both of those justices, since they've both written on this now, have pointed out the numbers from Google, and at least Google and YouTube, I think, is my memory. I'd have to look. To show the kind of dominance that at least those two applications have in the market. Do you take issue with those numbers and the impact those numbers have on keeping others out of the market, or is there some, or it's just not as serious a problem as if you just read it and you don't have any economic background? It sounds powerful.
I think it's easy to get distracted by these kind of raw numbers. These are incredible, successful platforms, which is something we should all be excited about. That means more people have an opportunity to have their voices heard than would have had in an era where you had 3 TV stations. I think this does go to some of how we need to consider this as it relates to other questions around speech more generally, not in the sense of access to those platforms, but how this could actually also impact must-carry requirements on more traditional media and the concerns that that would have around broader freedom of the press and free expression issues there. I would also echo and commend there is a much broader conversation, particularly in oral arguments, around the common carrier argument in the net choice cases, and I find that the court seems largely skeptical and rejecting that, although, as you mentioned, it does not necessarily explicitly go as far as say as to firmly state that, or to say overturn Pruneyard or something along those lines.
Anybody have any comments on that before we?
Yeah,
Yes.
I mean, I like competition, so I'm sympathetic to a lot of the points you're making, but one form of competition that gets forgotten here is federalism. So just from a policy perspective, like New York and California, if allowed to do this, will do a very bad job. And there's other states that I think would do a much better job. But they don't even get the chance to try when the First Amendment applies. Now, if it applies, then that's the end of the story. There's nothing we can do about it. But I don't think we should be so quick to assume that because one state passes a bad law, it'll be a catastrophe. That used to be the case, but we just saw in the pornography case, the court just decided the age verification law from Texas applies only in Texas, and from what I understand, these websites they can basically target the age verification thing to that state. So they can turn settings on and off depending on what state they're in. And so I think one thing that would be nice to know is how these things work in practice, and our federal system does provide an avenue to test these ideas for states to serve as laboratories, but until they're allowed to go into effect, we're just not going to know the answer.
I don't want to keep Tom from his comments too long, but I do want to mention this because, normally I'm a big fan of federalism. I think that oftentimes governing on the most local level possible when necessary is the best response. However, when it comes to the internet, so much of the internet is by its very nature interstate commerce, which means that it is a ripe issue for the federal government if we are going to see a policy, not the state government. So you can think about this particularly in the online speech context when you think about the nature of the interactions that would be involved. When you think about the fact that to do this would potentially isolate state speakers. And I do have concerns about the impact of laws from a single state like California or New York on the broader country, and particularly around online speech issues as well as around other issues of technology. And I think that's why we have seen traditionally a deregulatory federal framework present in laws like Section 230 that recognize that this was an issue from the beginning of the internet that needed to be dealt with at a federal level, not on a state-by-state patchwork basis.
Anyone else on that topic before we go to Mr. Johnson on that topic? I have a different question for you, but I don't want to confine you. But you, as I mentioned in your introduction, you are no stranger to the debate over considering policy related to regulating digital access. Address whatever you feel relevant to what we've been talking about, but generally speaking, where did we stand 6-8 years ago on this topic, and how do you see it now past the net choice litigation?
Well, thank you very much, Judge. Really appreciate it. Really appreciate the opportunity to talk to all of you today. I mean, as the judge said at the outset, I did survive the net neutrality wars of the first Trump administration under Chairman Pai, and the internet also survived the net neutrality wars, despite CNN saying it was going to be the end of the internet as we know it on the day of the vote to repeal the Obama-era net neutrality rules, despite the fact that the chairman and others received death threats. We had a fake bomb scare called into the FCC, interrupting the vote while we were doing it. So a lot of passion and a lot of hysteria around that issue. And one of the things I want to impress upon all of you is just how much some of the issues that have been salient in the public mind have changed, how the technology has changed. I think as the professor was alluding to, and as Jennifer also mentioned in her comments, that it's important to kind of look at different technologies, different companies, different layers of the internet stack, and say, how are they acting here? Are they acting in an anti-competitive way? Are they acting in a way that would qualify as expression under the First Amendment? Because it's not going to be one size fits all necessarily. It could be that different parts of the ecosystem require different public policy responses and may also require different constitutional analysis. So if you take net neutrality, for example, and I think this was what was very much in the news, 2016, 2017, one of the big reasons I decided to accept the job at the FCC. I thought this would be a lot of fun to work on. It was right after John Oliver had given his diatribe about how terrible it would be if these rules were repealed. So there's a legal question involved there, and this is one area where Congress actually has spoken to common carriage principles, at least with regard to the old Ma Bell telephone network, starting with the New Deal era Communications Act. A lot of those principles, non-discrimination, just and reasonable prices, kind of worked into that federal statute. So there was a big legal question involved with net neutrality as to whether those statutory provisions applied to modern broadband networks. We argued they did not. We were affirmed on that under a Chevron regime. Now under Loper-Bright, the Biden administration tried to go back to an understanding in which we could regulate these companies as common carriers, and that rule was struck down. And so now at least it appears that that part of the debate, the legal debate, was over. But there was also a significant public policy case going on there where, particularly the left, including a lot of the big internet applications, a lot of the social media companies, they wanted to interconnect with the networks for free. They were strong supporters of net neutrality regulation. But the case, the public policy case, was not there for the internet service providers. There was no evidence that these companies were blocking or throttling content. Much like the telephone network, people expected that if you wanted to access a website, you could access that website. And in fact, that is how they marketed and sold their product, right? From the very beginning, it was surf the World Wide Web. It was purchase this internet service and you can access all endpoints of the internet, right? That was the business model. That's what made the product so popular. There also wasn't really a competition-based case for treating these entities as common carriers, right? I mean, you have fierce competition between the traditional telcos and cable companies. There's just a Wall Street Journal article just last week that Chairman Pai and current Chairman Carr played up, showing that competition was driving prices down in the marketplace. Now you've got increasing competition from mobile services, satellite services, Elon Musk's Starlink. So all of this stuff is increasing competition in the marketplace. So apart from the law, we also looked at the public policy case and we said there was no reason for the prescriptive rules in this context that come with common carriage, right? That the market was largely taking care of these things. Particular examples of anti-competitive conduct, to the extent that they occurred, could be handled via enforcement, could be handled via the consumer protection laws. But then ironically, what we saw happening towards the end of that administration, right, is some of the anecdotes Ben and others were sharing with you today, right? We saw in the wake of the COVID, the COVID pandemic, how some of the social media companies, some of the biggest supporters of net neutrality, were now blocking people supporting the lab leak theory. You saw right before the election, the social media companies were shutting down links to the Hunter Biden laptop story. And around that same time, we at the FCC announced that we were going to take a look at how the Section 230 immunity shield that traditionally applied to to those companies was being interpreted through the courts. We ended up with, when President Biden took office, we weren't able to complete that proceeding. But then, kind of fast forwarding just a little bit after that, we see a new problem emerge, right? So, we talk about competition in the marketplace, and, obviously the great benefits that come from having different options, different companies being able to do different, have different kind of community guidelines, different content moderation rules. But you saw in 2021, kind of I think right after we left, a lot of the app stores started deplatforming new entrants into the market like Parler. Some of the web hosting services started doing that as well. And so again, kind of looking at those different layers of the internet stack, can we have effective competition if it is difficult, if there are these barriers to entry for different companies to come in and have their own content moderation rules and to and to compete with some of the bigger players. I think as the professor kind of alluded to, you know, in a lot of these cases, we are looking at that competitive impact. We're looking for, is this a natural monopoly or is it an actual monopoly? But I think also some of these common carriage doctrines are a little bit broader than that. Kind of the traditional common law test is, are these companies affected by a public interest? You know, not always clear where those lines are, but it was these kind of categories of essential services, where there's a question. I mean, a lot of these things applied to travelers, people who were stuck on the side of the road, you know, and they had to have access to food, lodging, transportation, vehicles, things like that. And so you have these cases of real harm. For example, the Hunter Biden laptop story, right? Like, that's going to impact the outcome of an election or not. The prospect of competition down the road is not going to change. There's a real public harm there. Same with COVID-19, you know, misinformation, disinformation. If you have that out there in the public market space, if there's a public health effect to that, right, that's going to be permanent in a lot of these cases. You know, the fact that a new entrant might turn around, the fact that Elon Musk might buy X 2 or 3 years from now doesn't really get to that type of problem. So I think that's what kind of gave rise to, in the social media ecosystem, these questions of, unlike the ISPs, is there an appropriate role for a public policy solution here? I'll make a few comments just to conclude on kind of openings. We talked about this a little bit, that I think that even after Net Choice v. Moody, we might see the lower courts kind of engage in analysis. We might see these issues kind of continuing to work their way up and percolate. I think, first of all, even the majority opinion in those cases recognized that competition policy can be an effective way to deal with some of the problems in this area if you do have barriers to entry, if you do have monopolies and things like that. I think Chairman Ferguson, Mark Meadow, and others have kind of talked more about these kind of democratic harms that can come from private companies having an impact on our ability to have a robust marketplace of ideas. I think the court and the dissents kind of pointed to Turner Broadcasting as one example of this, where at that time it was considered that cable channel space was limited. It was important to the broadcast industry to have access to that channel space, and so the FCC's must-carry rules were upheld on that economic, at least in part, on that economic rationale. The other thing I think the majority opinion recognizes, and the dissents obviously also point out, is just, again, how much this technology is evolving and how much it's going to depend on the record in a particular case, and what service we're talking about in terms of what that record looks like. How does the content moderation actually take place? So the majority puts to one side, for example, what about algorithms that are simply trying to mirror or reinforce existing user preferences, right, to get people continue to be engaged or addicted, whatever your preferred word is, to the screen, continuing user engagement? Is that expression in the same way as people making conscious policy-based decisions? They also talked about how AI is increasingly being used to make these sort of algorithmic decisions. You even have AI models training on AI models. So at what point is the human participation in these decisions so attenuated that what you actually have here is really a business practice? It's a commercial business practice. It's not free expression. And then, as I think a number of these folks have been talking about, I think we've all touched upon it, is the fact the majority really didn't grapple with the application of common carrier principles to these entities, and whether the First Amendment analysis might be different with respect to going through that traditional common carrier analysis. Again, this was sort of a facial challenge to these laws. So I think one important question, both for these cases on remand and in other cases, is going to be, can this kind of flexible framework that we've described, can it be an appropriate fit for some of these cases where private companies are engaging in censorship or deplatforming or deprioritization?
Thank you. And Professor and Ms. Huddleston, I want to give you a chance to follow up on anything that you have heard, but to also throw out there is, because I think everyone has alluded to it to some degree, maybe the previous panel talked about this as well, but is there some interaction or overlap between legal antitrust concepts and principles and content moderation? You don't have to answer that, but if you want to, that'd be great. But you can also respond to what else.
Yeah, I want to jump in on this question of kind of the idea that content moderation is a competition issue. And I think to see that would be to really shift away from our traditional understandings of the consumer welfare standard, and in an area where we do see robust competition. If you look at the way content moderation is evolving, where you're seeing platforms respond to their consumers' demands, and their consumers being both their users and their advertisers in these cases, that we do see a market response. One can look at the various changes we've seen, whether it's X under Elon Musk, or whether it's recent changes at Meta, or whether it's the emergence of new platforms like Truth Social, like Parler, like Blue Sky, like Mastodon, when people find that they are dissatisfied with the options that are out there. Another unique element is that these platforms, we don't see that it's an either or. Many users are engaged in a multi-homing practice, so you may be using multiple of these platforms at the same time for different types of expression, for different types of networks. And so you really are not just having a kind of single actor or anything of that nature, and that they still continue to compete with each other, particularly not only the large platforms, but also these more niche platforms that may be providing services. But I think that the question at hand, too, is what would happen if we start to see competition policy used because of concerns around content moderation. And I think there are two problems with that approach. The first is that it would much broaden the way that competition policy could be used in general, potentially opening it up to other policy goals that different people in power might have, and again, making it more difficult on businesses on all sizes, and ultimately harming the consumers who are theoretically at the heart of antitrust here in the US. The second is, what would happen even if this won? If you saw some sort of breakup of a major platform on the grounds of their content moderation policy? Well, there's no guarantee that smaller platforms would have any different content moderation policies. If they're still trying to track a general user base, if they're still trying to maintain a same degree of advertisers, there's no guarantee that that policy would change. And in fact, it might even be more difficult, or in some cases, it might even be more risk averse. So a platform that's more dependent on advertiser revenue may be less likely to be willing to host something that others might consider controversial. They might engage in more heavy-handed content moderation if they're concerned about chasing away certain users, or might be unable to afford the latest tools to get rid of things like spam that most of us would want to see less of in our feeds. Let alone some of the other concerns that can arise with having a smaller platform with fewer resources, less able to respond to general concerns.
Thank you. And Professor, you, of course, are in the legal space. You've been in the public policy space, and you've straddled both spaces. So give us, follow up with any of this and give us your views.
Yeah, so I disagree with some of the points that have been made, particularly around thinking about competition in these areas. And to just see the places where this applies, go back to that Louisville case of the Carriage company and the telephone. In requiring the telephone company to offer telephone service in a non-discriminatory way to multiple carriage companies, have we undermined competition? No, we've actually encouraged competition. There's now multiple companies that can use this telephone service, that can get customers to come to them. We've actually created more innovation because there's more people who have access to this important resource. You could think about this similarly in the context that Thomas mentioned earlier, Amazon Web Services, these kind of core cloud services that are essential for almost every internet business. If they lock you out, where are you supposed to go? Well, Google Cloud Platform exists, also Microsoft Azure exists. Those are the big three. After those three, if they all lock you out, there's not really an option. Are you going to really buy all the semiconductors that you need yourself and create your own cloud system to run your own internet service? Very, very high capital costs. You may not have enough money to do that. Certainly not the kind of thing you're doing from like a garage-based startup that is how we imagine at least internet entrepreneurs. So a non-discrimination rule in these cases might actually there to increase competition because it increases access to this basic infrastructural utility service that's necessary. Now, non-discrimination remedies are very common in antitrust cases. They are a policy for encouraging dynamic innovation and competition, and they're a remedy when platforms are engaged in the process of basically stopping different actors that use the platforms or increasing costs for them, locking them out altogether, charging them unreasonable prices, giving special deals to some versus others. And we see these kinds of practices in the tech economy all the time right now, and that's partly why there are cases that have been brought at the state level by attorneys general, at the federal level under the Trump administration and the Biden administration against a lot of the big tech companies, and they allege all of these kinds of harms against various different tech companies. And so I think there's real space for antitrust and competition policy to actually get at these kinds of harms with remedies that increase the access and competition that we have. It's a kind of downstream innovation and access that is essential when you have these inputs that are very hard to replicate, but are critical services for lots of different kinds of economic or other commercial activities. Now, how that exactly operates in the context of social media may be different because of the First Amendment, but it's not analytically different in terms of the kind of thing that we're talking about. So if AWS, as I said, excludes your internet business because they don't like you because you're a Washington Nationals fan, that would be a real problem for you. That's a content-based discrimination in this, what looks like a business-to-business thing that we wouldn't call content moderation in the sense of what are your posts on Facebook or X or some other service, but it's a similar kind of thing. If Amazon Marketplace deprioritizes your good that you make as a small business and puts you on page 27, how many people really go through and click through to page 27, versus putting you on page 1, that's a real problem for your business. Is that content moderation? We may not call it that, again, in the social media context, but it's quite similar to the reasons why we have these non-discrimination rules under common carrier regimes, and that are often applied as a remedy in some of the most famous antitrust cases that we've had in this country. And so I think I take the view here that competition policy can actually be helpful in a lot of these cases by drawing on these common carrier principles. You can do it either legislatively through common carriage, that requires a lot of specificity and learning on the part of legislatures. You can do it on a case-by-case basis with judges doing it under the common law. Also has some challenges. You can do it through an antitrust remedies case as well, and we're seeing that play out right now. So I think the vehicles are different, but some of the principles here are pretty strong ones.
Thank you for that. Two things real quick. I neglected to say, Mr. Johnson, Ajit Pai, and others 6-7 years ago did their research, analyzed the issue, and came to a policy decision, and then stood very strong in the face of immense public pressure against their position. I know, of course, Mr. Johnson's here today. Ajit Pai is a frequent contributor to the Federalist Society, and so we should never forget that and commend them for them standing strong when they were wearing their public service hat. I want to turn now to Mr. Flowers because we are at a Federalist Society event, and someone has to talk about originalism somehow. And so let me open the door for you to speak about originalism of the First Amendment more generally. And then, if you have time, if you don't mind, there's, I wouldn't say a back and forth, but Justice Barrett talks about the algorithms and their ability to curate content and how that might be one way in which the First Amendment might apply. And then there are AI-generated algorithms, and the First Amendment might or might not apply. Justice Alito talks about this as well, and talks about in the context of the vast majority of information going through these platforms. There's a word I'd never heard before, 4 petabytes of data for Facebook and YouTube alone, and I have no idea what that means, other than it's 1.3 billion times as many bites as you would have in one New York Times issue. So originalism or AI-generated algorithms, how does the First Amendment play out?
Yeah, look, I think, I'll just take them in order. On originalism, I don't have that much to say, other than, aside from Professor Campbell, who spoke earlier, there just hasn't been that much work done on it. I think the odds that our current First Amendment jurisprudence the odds that it tracks the actual original meaning of the First Amendment are vanishingly low. It didn't appear till the 20th century. It has tiers of scrutiny. I mean, I think it's something of an embarrassment for originalism and originalists, which I count myself as one. When you read Adrian Vermeule's book, for example, there are a lot of things I disagree with, but when he gets to the First Amendment and says, this is all made up, it's kind of hard to disagree with him. I think we need to do a much better job grounding the doctrine in the original meaning of the text, which will require people who have more time than I do to figure out what that original meaning was. That's point one, but I think this is actually, I found a persuasive point in Judge Oldham's opinion for the Fifth Circuit in the net choice case, where he says, look, as an original matter, it seems like all of this would be allowed, so we can start there and ask if doctrine prohibits it. But look, short of that, we're not going to undo all of First Amendment law. I don't even think the game would be worth the candle, because I think whether it's grounded in the original Constitution or not, it's actually pretty good law, good policy, and so if it were overruled, I think there'd be a constitutional amendment very quickly, just putting it right back in place. So I'm not advocating for that, but what I do think can be helpful is in determining how the First Amendment applies to new technologies. We can look to the original meaning. We can look to doctrines like the common carrier doctrine and make the doctrine we have better fit the original meaning where appropriate. The AI-generated algorithms that the Justice Barrett expressly reserved a view on, Justice Alito as well, are interesting. Probably 10 years ago, maybe 12 years ago, I remember Barack Obama was saying the coal miners, they just need to learn to code, or maybe it was Biden. It was somebody in that administration. And that just shows you how bad experts are at predictions of the future, because a lot of experts were saying that, but it turns out that the coders should learn to mine, because coding is the easiest thing on earth to replace with AI. And so the coders will be the first people out of jobs because of AI, because AI can very quickly learn how to code for itself. So why does that matter? I think it matters because it's one thing to say if a human being designs an algorithm that weeds out certain information and presents others, there's some sort of editorial discretion there that starts to look like speech. But when it's a language learning model that's looking at what gets attention or other things and drafting code to make that happen in the future, and it's sort of can build on itself, it becomes much, much harder to tie that to any individual or entity's conscious decision-making or speech in any way. And so I think the argument that the First Amendment would apply to algorithms like that is significantly weaker than the argument that it would apply to man-made algorithms, for lack of a better term.
I know we're already past, we're in the question period, but I wanted to, before we get to the question period, Mr. Johnson, I wanted to end with you, given your past life, what role, if any, do you think the FCC ought to play today going forward to these issues?
Sure. Well, I really appreciate that. That's actually where I was going to go next. I think, we've talked a lot about state authority. We've talked a lot about the common law. We've talked a lot about the courts and the First Amendment. I think one actor that's sort of missing from this conversation, first and foremost, is Congress. We've had two major enactments relating to communication services at the federal level. Like I said, 1934, I believe, Communications Act. Emerging radio services, telephone services at the time, much more of a monopoly than it is today. And then in 1996, a big amendment to that statute for purposes of, at that point, the emerging internet economy, and things have changed a lot since then. So the Sixth Circuit's decision in the Title II case, the net neutrality case under Biden, I think reached the right result, saying that under that law as it exists at that time, the FCC does not have significant authority does not have Title II authority, at least, over broadband networks. With respect to social media companies and edge applications, We under Chairman Pai, we put a transparency rule in place that applied to broadband networks under a provision that could be read more broadly to permit transparency at the edge. We've heard Chairman Carr express some support for that proposal. There's Section 230, which is part of the Communications Act. I wrote a blog post while I was FCC General Counsel, in which I took the position that the FCC did have authority to provide interpretation of that statute to kind of guide how courts were resolving particular cases involving it. But we have to be candid in thinking that this is not a comprehensive piece of legislation. I think it's not something that, if you didn't have all of the transaction costs associated with passing new laws, that you would assign to a regulator responsibility for only a very small portion of what's become a new and evolving internet stack. Like, I'm certainly not, in favor of kind of heavy-handed federal regulation. I'm not in favor of being very prescriptive, in regulation. But, there are things, the internet service providers have long favored a bipartisan compromise in which some of these baseline non-discrimination principles would be written into law. Right now, when you have this patchwork quilt of state regulation, one downside to the federalism approach, when you're dealing with nationwide networks, nationwide services, is that there's a risk of kind of the lowest common denominator prevailing. Whatever the most onerous requirement is coming in from really Sacramento and Albany, we're seeing this in broadband right now, is that's what becomes the de facto standard, because it's less expensive for these companies to roll out a single policy nationwide than it is for a patchwork quilt. I think Ben makes a good point. For some of these software applications, if you know where the towers are and where the consumers are, you might be able to differentiate. That obviously imposes some cost, but I think especially for the hardware, the infrastructure, that sometimes becomes impossible to have like a Texas network and a California network. So I would still be an advocate of some kind of more uniform rules of the road to govern this ecosystem as it exists today.
Ms. Huddleston, you are an expert on the interaction with the administrative agencies and the digital platform.
I want to kind of comment on this and in three ways why I think that the FCC does not have authority to engage in Section 230 rulemaking. First off, I think the statute itself is pretty clear, but if that's not clear enough, how often do we say, I wish I had known what the drafter's original intent was? I wish, we could call up the Constitutional Convention and ask them, what did you think about the First Amendment? And by golly, if former Representative Chris Cox and Senator Wyden are not actively saying, we did not intend to delegate this authority to the FCC. In fact, in the congressional record, it clearly states we do not want a federal computer commission. This is now a law that's almost 30 years old, but the two authors have very recently in any of these proceedings stated that this was not their intent. But if that's still not enough for you, I would point to what we've seen recently in administrative law with Loper-Bright, with some of the shifts around non-delegation and things like that, that you don't have a clear congressional delegation, at least at this time, to the FCC or to the FTC to engage in Section 230 rulemaking. And I think in that regard, that means that we should not see administrative state action, and that we should be very concerned from a separation of powers point of view, from a role of the administrative state point of view, if we start to see this kind of engagement in a law where, to me, it is so clear that this is beyond the scope of the law. And I think you would likely see a similar case to what you've seen with net neutrality, where the courts have found that there was not the authority, first under Chevron and then later under Loper-Bright, which I think those decisions are correct, and that you would likely see a similar response in a Section 230 related rulemaking.
Yeah, just on that last, on your last remarks, I will talk about the legislative history portion of that, having worked as a staffer in the Senate. I would not put a great deal of stock in floor statements, and I would commend you all to a National Review article commenting on, I think it's the Hamdan decision, Osama bin Laden's bodyguard, where Justice Stevens commented on floor statements given during that debate, and gave more weight to some floor statements because he thought they were done live, and less persuasive to Senator Kyle and Graham because he thought those were put in the record after the debate. And it turned out the National Review went and looked at the C-SPAN floor debate, and neither one of them gave those statements live on the floor. So but that's just the legislative history of your comments. Did you have something else?
Can I make one?
Well,
Yes.
it's just-
One quick related comment on the legislative history point. Is this on?
Yeah.
I just wanted to add, General Scarametti earlier was telling the young lawyers, go pursue, time in a state attorney general's office. And there are many reasons to do that. I agree with everything you said. But one really great thing about state AG's offices is when you're dealing with state law, most of them don't have legislative history, so there's not even a temptation to have to deal with it.
Mr. Johnson.
Sure. No, I'll add just a couple quick points. I know we want to go to audience questions. So I think in this instance, it's even worse. I mean, the floor statements, they are relying on the floor statements, and, the floor statements of two members of Congress, right? I mean, typically we, at the Federalist Society, we start with the text of the statute, right? And you don't really, jump. And even with respect to kind of a hierarchy of legislative history, you tend to look at conference reports, things like that, before you jump to floor statements. But here, I think it's even worse because a lot of this has kind of been worked out through amicus briefs that they have submitted in the record. So it's what Justice Scalia used to call, right, post-enactment legislative history, right, which is a bit of an oxymoron. I do think that things have changed. Obviously, they've changed for the administrative state entirely, with respect to Loper-Bright overturning Chevron. It very much affects the level of deference that agencies are going to receive across the board going forward. But what I think it's important to distinguish is that Loper-Bright doesn't change the ability of federal agencies to adopt rules. They still have rulemaking authority. They still have interpretive authority. They still interpret their organic statutes in the first instance. The question's going to be what level of authority that's going to get. And I think as the Supreme Court said in Loper-Bright, and it re-emphasized in the McLaughlin case, the Hobbs Act case, which governs the FCC, which came down just last week, it's an appropriate level of respect based on, the strength of the reasoning, the technical expertise that the agency brings to bear. So to me, this is less a question of the authority of the agency to interpret its organic statute than it is the level of deference that it would receive in court.
I feel compelled to say, despite my, I'm sympathetic to a lot of the concerns about these social media companies, but I'm very wary of having a federal agency get involved. Number one, because very few things get better when a federal agency gets involved. And second, because I frankly prefer the Federalist solution, because this is really hard stuff, and I would much rather have multiple experiments, see which ones work. I do think these companies can deal with different regimes in different states, and at least having a little bit of time to experiment to see what works and what doesn't.
Very good. Anyone else before we see if anyone has any questions? Anyone else? Okay, anybody have any questions? So we've got a great panel with a deep a depth of knowledge here. Yes, sir.
Yeah, thanks. I enjoyed the panel. So I wondered if there's a non-barking dog problem with applying a common carrier conception historically. So back in the day, there were a lot of states that only had one or two presses. There also were frequent complaints that the editors of those presses were exercising editorial discretion in ways that were partisan. And I would think that if the common carrier concept was around at the time, people would have taken hold of that, and I'm curious why they didn't. Is there any sense from the briefing in Net Choice or any background understanding as to common carrier law, why the common carrier concept wouldn't have just straightforwardly applied to printers in situations where there was a sort of quasi-natural monopoly happening?
Professor, you might be good at this, but I don't want to limit it to anyone.
I'm not sure specifically on printing presses as the machine, the printing press, for example. So would want to look at cases to see. I've not looked specifically to see if there are places where printing presses were in scarce, were scarce because of high costs, or there was a monopoly on printing, and if there was some court that made some decision there. Generally, I think newspapers were not ever thought of as common carriers. And so that I think is a different category, and obviously a conversation about editorial discretion and the First Amendment and applies there. On the access to the press itself, could a press that is a monopoly exclude or not exclude specific printers, specific newspapers who wanted to print kind of content? I'm not sure, I haven't looked, but that would be an interesting question.
Anyone else? Yeah, okay. Yes.
Hi. So some people insist on calling it content moderation. Others will insist on calling it censorship. But however you look at it, one of the biggest cases in this area that I hadn't, at least I don't think I heard mentioned today, was the Murphy versus Missouri case. Of course, this came out of COVID and the Biden administration sort of impressing upon social media platforms to restrict or ban what you could say about COVID or about vaccines. The Supreme Court 2 years ago went against the District Court and the Fifth Circuit, sort of narrowly finding a way for the president, or at least the administration, to be able to continue to, in a sort of backdoor way, have this influence over the tech platforms. And I was just curious your reaction to that case and how the Supreme Court came out, and what you think about that issue in that case.
Did you guys have a role in that, or do you have thoughts on that?
I don't know if we filed it. I think Ohio did. I can't remember if I was still there, but I do have thoughts on it. I mean, in terms of the standing decision, I would just like the Supreme Court to articulate a clear rule of standing at some point that doesn't change depending on the party in power. With respect to the censorship, I mean, I guess what I would say about that case is, for those concerned about concentration of in the market with these companies, this highlights one danger of that. Is it's a lot easier to pressure a small number of companies to censor things than it is to pressure an enormous number of them. And when you look at the record in that case, it really is pretty shocking. And for those who haven't, I'd recommend that you do so. I mean, the Biden administration was very aggressively pressing these companies there's no argument. They were censoring information, and they were censoring it at the government's behest. And so, it sure seems as though they're acting effectively as agents of the government. But part of this is the concern with, a fair point Jennifer raises, once the government gets involved in regulating, they can use that to force private actors to act as they wish. And there they had active antitrust suits, if I'm not mistaken, against these companies. And so they had quite a stick to threaten them with if they wouldn't go along with what they wanted them to do. Now, I think whether or not there's a suit against the social media companies there, it's disturbing that would not be considered a First Amendment violation when the government is actively pressing them to do it on their behalf.
Yeah,
I think-
and the companies needed help with European regulation from the administration as well. So it wasn't just the antitrust suit here, it was the diplomatic need at Huddleston.
Right, there were several things that were concerning in that case, and as was mentioned, the Supreme Court ruled on standing, and so I think there are a lot of interesting questions around who would have even had standing if not given this fact pattern kind of thing. I would commend some Cato papers by my colleague David and Sarah, as well as a paper by Kristen Shapiro and Andrew Grossman on censorship by proxy. That's my favorite term for what happens. You often hear it called job owning, the kind of idea of the government, nice company you got there, would be a shame if we, by the way, have you seen this kind of attitude? But what you're actually seeing is government pressure on a private actor to engage in a certain type of behavior. And that when that comes, we should also be concerned about these private platforms' First Amendment rights, their ability to make their own private decisions around how to operate. And so that is a First Amendment concern as well. One of the many things that can be highlighted here is the need for transparency around these kind of government actions, and how sunshine is often the best disinfectant. There may be times where there is necessary communication between a company and the government, or vice versa, but to have that kind of sunshine on it so that individuals are aware and can distinguish between different types of pressure versus kind of transparency in general, I think is going to be very important.
Just Just a couple of thoughts. I think this is a very complicated area, and I'd encourage you to listen to or read the transcripts of the oral argument also in the case where the discussion of job owning gets into a lot of different hypotheticals that, some of the justices who worked in federal government in the executive branch, were thinking about, I think, which is, if you have a case where a newspaper knows about some sort of national security thing that's going to happen, say, the next day, a military operation or something like that, is it okay for the executive branch officials to call them and say, please don't publish this beforehand? There's no law there, right? If you're thinking about the First Amendment, there's no law that's being imposed. There's no regulation. There's no stick from, I'm going to threaten you with an antitrust lawsuit or something like this. Should that be allowed or not? And, where then is the line between that case, if you think that should be a permissible call from the national security advisor to an editor of a newspaper to, the cases here? I think there's just hard questions there to think through if you're going to have a principled answer to the question of job owning when there's no legislation, no regulation, no specific threat of a kind of remedial action or something. That's a hard case. I think it also raises a question about to what extent in these cases do you care about formal kinds of rules versus informal exercises of power? And, to go to where Ben started, if one of the great concerns in the American system is the concentration of power, I think one of the concerns that people have learned in the last decade is that very powerful private entities can also exert power in a way that seems like governmental power, and that's where the discussion of calling something censorship, we normally think of censoring as a thing the government does, not a private company. But if a private company does it and you want to call it that, well, what's the nature of this power? There's no law or regulation forcing them to do it. It's not public power authorized by a legislature or something like that. So I think there are hard questions here on how formalistic or functional we're going to be about power. And so, I think these kind of job owning cases raise, I think, some very difficult questions that are interesting to, teach in a law school sense. There's a lot of hypotheticals you can come up with there to kind of push on what your intuitions are. But I encourage you to look into those more because I do find that it's a quite a thorny place.
Any others? Yes.
In discussions about these issues online and in the media, I've often heard it repeated by some people almost as a dogma that these are private corporations, and as private corporations, they have the right to exclude who they want to exclude, to platform who they want to platform, deplatform who they want to deplatform, et cetera. And I'm curious to hear from the panelists, particularly those who agree with the application of the common carrier rule to these corporations. Why is it justified as a matter of political theory to force platforms, which as private platforms putatively have a right to make their own judgments about who they want to platform, who they don't? Why is it justified to force them to platform people?
So I think that's the whole genesis. You would know more than I do, but of the common carrier doctrine and of interventions in market operation more generally, like antitrust, is that when competition breaks down, absent law, the power can be abused. And so in the common carrier setting, you're dealing with someone who has consumers sort of over a barrel, like they're traveling and they have no other place they can turn, or they only have the one telephone company they can work with. And so we need to make sure that they have access, because the market, though it would usually guarantee access, won't in this discrete circumstance. I want to be clear, though. I'm open to that argument, but I also think the people advocating for that need to be honest about the fact that there is a slippery slope problem there. I think they need to be very, very careful about over-invoking that and allowing the government to intervene in the market in all sorts of circumstances in which it's not justified.
Before we wrap up, I think this question, though, also elicits another response, which is a reminder that there technically is nothing that stops the government from creating publicsquarebook.gov, either as a state government or as a federal government. I think most of us can kind of guess what quality of internet social media platform publicsquarebook.gov would be. But if the government were to create its own social media platform, that would then be subject to the First Amendment as a government platform. And that's very distinct if we're talking about a public government platform than when we're talking about these private businesses and their decisions.
Well, you mentioned political theory, and I guess I would just say on that, I mean, if you came at this from a purely libertarian perspective, you might say, well, there's really just the government and individual citizens, or, artificial corporations with the rights of individual citizens. But I think if you took, a more communitarian approach or more Aristotelian approach, as the last panel was discussing, and you asked, are there public policies that could inure to the general welfare, the public interest? I mean, this is the FCC standard public interest, convenience, and necessity the Supreme Court just upheld in the Consumers Research case last year. That is classic language that is applying to a third category of entities. It's the common carriers and things like that we're talking about, or government licensees. It's entities that have that are given special privileges, have a special place in terms of the services that they're providing, and therefore that comes with certain obligations. And I mean, to Ben's point, kind of rediscovering what we've forgotten, it's true that our kind of muscles have atrophied because of the fact that our First Amendment jurisprudence is governed basically by 1960s era and post-1960s era case law. It would have been very familiar to the founders, and your scholarship talks about this, that certain classes of corporations would have certain special responsibilities, obligations to the public in exchange for the public benefits and licenses that they received.
And I would just say, there's Justice Thomas's opinion in Biden versus Knight, First Amendment, Institute of Columbia. He goes through it. It's not an easy question. There's a long analysis where he breaks it down as to how it might apply. And you get the Pruneyard decision and that decision and others that would help lay it out a little more. Yes. Okay, so we've used all of our time. I want to make 2 points before turning it back over. And the first is, and you may be addressing this, but there's a reception just down the hall, 180 degrees from us, I guess, number one, but I'll leave that for you. But I did
180 degrees directionally or temperature?
So it's like Justice Campbell, the fireside chat. Got the fire going in there. But I did want to say thank you to our panelists. This was a wonderful panel. And turn it over to Mr. Kazmarek.
Thank you, Judge. Many thanks to you and our fantastic panel. Great insights and hopefully some fruitful disagreement too. It's been an excellent day of discussion, and our final panel was no exception. I'd also like to thank my many FedSoc colleagues for their tireless efforts in putting together today's conference. Please do give them a hand. Lastly, as we announced earlier today, we are grateful to Alita Cass, for the former director of the Freedom of Thought Project. If you'd like to sign the thank you poster to her, we've moved it to the reception space, which is across the hall. With that, thank you all for coming. We are adjourned.
Thank you.